following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the laws governing bail in Sri Lanka. The concept of bail is one that is viewed in a polarizing light by the general public. What is the true purpose of being granted bail by the court of law? How does the process of being granted bail differ across the legal spectrum? And how does bail relate to fundamental rights such as personal liberty? A very good evening to everyone joining us on Law, Land and Liberty, where we bring to you pertinent legal topics of discussion and providing the layman with a comprehensive analysis of the subject at hand. Now, bail is not a concept that is new to any citizen of the general public. We may have heard of it over the news or simply know of it through media, and most of us may have never had to undergo the process of applying for bail and what that entails. And because of this, there is a vacuum of understanding on the subject. Now, to better understand bail beyond the surface level, we have with us a very important individual who is quite experienced in this field of law among many others, and that is President's Counsel Kalinga Indatissa. Thank you very much, sir, for joining us today. Mr. Kalinga is a lecturer at the Law College, University of Colombo. He was also the BASL, the Bar Association of Sri Lanka's president from 2019 to 2021. And of course, we're really looking forward to exactly how we're going to break this topic down with you, sir. Thank you very much once again for taking the time to speak with us. Now, before we get into the discussion, we're going to talk to you with a breakdown. Now, as always for our viewers, we have to give you a breakdown so you know exactly what areas we will be covering today. Now, first, we will get into the basics of bail. What is bail and what legislature allows for bail? Secondly, the procedural aspects of bail. Now, how is bail granted for different allegations? And we'll also touch a bit on the anticipatory bail as well. And finally, we will be talking about the reforms aspect of the legislature.
Hello, my name is Omira Samaravira and I am a medical student. My question is on provisions. What legislature is responsible for the provision of bail?
All right, well, without further ado, let's get right into the discussion. Sir, now, we know about bail and we know about the existence of bail, and a lot of us will understand bail as a financial aspect of criminal procedures. But a lot of us don't know exactly what bail is. So if you could start us off in this discussion with exactly telling us, what is bail?
Well, Anuradhi, I'm thankful for having been invited this evening to speak a few words on this important topic. You will see every criminal justice system commences at that point when a person makes a complaint to the police or the law enforcement authorities. Once a complaint is made, there are some cases where the suspects are known or the culprits are known, and some instances where they are unknown. Wherever an investigation commences consequent to a complaint, the relevant authorities will take steps to apprehend people who are suspected of the offence. It is at that point the concept of bail would evolve. Firstly, arrest is made. Thereafter, the law identifies a time limit that the law enforcement authorities can keep a person in detention, because in terms of the provisions of the criminal procedure code of our country, we have to produce the suspects within a particular period before a court. When a suspect is produced before a court, the question of bail arises. Bail means the court will have to consider whether further detention of the suspect is necessary or whether the court should grant bail or release him on the condition that he will appear in court on a future given date. The very concept of bail, Anuradhi, involves the passing of the person or the suspect from the custody of the court to the custody of the surety who will come forward to furnish bail for the accused or the suspect. So basically, bail is an important matter in the field of human rights as well as personal and individual liberty of suspects. So basically, bail means a person who is suspected of an offence is permitted to go home on certain conditions to be satisfied by him and on the furnishing of either financial security or the assurance of a surety, which is called surety bail, and then the court would release him and he can go back home, but he has a duty. The duty is he has to appear in court on every single day. That is basically bail.
So bail in its sense is not something more of a preamble to being locked up in prison, but rather it is somewhat of a financial promise where, look, we are giving you the possibility of leaving from these quarters if you agree to come back and appear for the court dates. So now that we know exactly the basic understanding of what bail really is, we should get into what governs bail and what legislature actually governs the authorities of bail. So could you tell us, sir, which legislature gives provisions for bail?
Well, you must know that basically the criminal justice system in this country, which is currently applicable to our courts, in our courts, is greatly influenced and enriched by the British law. We were under the British for a long period of time, the colonial system, and the British introduced their criminal justice system as part and parcel of our legal system. So everything, criminal law, bail, all these concepts have evolved basically based on the English principles of law. So now, having said that, what are the laws which are applicable? Until 1997, bail was governed by the Code of Criminal Procedure Act of 1979. In 1979, a new Criminal Procedure Code was introduced, and that provided for provisions relating to the granting of bail, the conditions on which bail should be granted. There are two stages. The moment a person is arrested, until a definite charge sheet is filed against him, he is referred to as a suspect. Once the investigations are concluded and a definite charge sheet is filed against him, he becomes an accused. So, during the period that the Criminal Procedure Code was in operation, until 1997, there were two segments. If you are a suspect, bail was determined by the provisions of Section 115 of that law, where there are different types of offences, bailable offences. Bailable offences would mean an offence where the accused has a right to ask for bail. It's a simple offence. Even the worst habitual offender would be entitled to ask for bail in that context. Then you have non-bailable offences. Non-bailable does not mean that you can't get bail, but you are in the hands of the discretion of the court. Court will look at you, your past conduct, and the possibility of committing further offences, seriousness of the offence, and then whether you are a person with a positive residential address, that is to find out whether your whereabouts are known, then the court can grant bail. Then there is the third type of offences where you deal with non-bailable offences of a serious nature. Murder, offences against the state. So, during up until 1997, the law that dealt with bail was the Code of Criminal Procedure Act. Investigation, Section 115. And after he becomes an accused, inquiry or trial stage, Section 402. So, different considerations apply. Initial stage, certain consideration, because the presumption of innocence is still not rebutted. It's in his favour. So, the courts will be more liberal in granting bail. But thereafter, if a person is convicted, that is called bail pending appeal. All these provisions were made in the Criminal Procedure Code. But in 1997, with the change of government in 1994, there were representations that were made to the Honourable Minister of Justice at that time, Professor G.L. Pires. Then the representations were to the effect that there was unnecessary remanding of people by magistrates. Now, technically, I must say here, granting of bail, remanding a person cannot be a punishment, because there is this presumption of innocence which is in his favour until he is convicted. So, overcrowding of prisons, we could not manage. So, a liberal law was expected. Now, bail is governed basically, in respect of most of the offences, bail is governed by the Bail Act of 1997, Act number 30 of 1997. But there are separate laws, serious laws, to which the Bail Act will not apply. That is because the seriousness of the offences, Now, say if you take poisons, opium and dangerous drugs ordinance, which deals with narcotics. In view of a narcotic problem, there are separate provisions ingrained in the poisons, opium and dangerous drugs ordinance to which the Bail Act will not apply. That is governed by the procedure there. Offences against Public Property Act, Antiquities Ordinance. So likewise, Witness Protection Act. Likewise, there are separate 3 statutes prior to 1997, the Code of Criminal Procedure Act. Now, the Bail Act of 1997. But there are separate statutes which deal, like the Prevention of Terrorism Act, the Poisons, Opium, Dangerous Drugs Act, which will deal with more serious offences in its own form. So those are the statutes that the law identifies as statutes which govern bail.
I see. So apart from the main legislature, the Bail Act,
yes,
there are separate for serious, other serious crimes where there are, within their statutes itself, bail provisions are granted.
Yes.
So when we consider the 2 separate, it looks like 2 separate entities, but it's actually not completely severed from each other.
Separate.
Yes. So does the PTA or maybe the Narcotics Act, where their bail has been mentioned, does it link to the Bail Act in any way?
No, it doesn't link to the Bail Act in any way. Bail is a basic concept that all the judges have to understand. That is, you can't remand people. You must remand only if investigations are not completed and if there is a reason for investigation. So the basic concept in the Bail Act is found in section 14. That says bail should be granted wherever possible. That is the new concept which was introduced after 1997 because of the overcrowding of prisons, as I said before. So bail should be granted wherever possible, but the problem is wherever there are special statutes, like the PTA. Now there is a lot of discussion on anti-corruption, anti-terrorism act. That's another separate subject. Now you may have, the law may be very stringent, but on the concept of bail, bail deals with a human right. Bail deals with the liberty of an individual. So you are dealing with the person who has not been convicted. Presumption of innocence is in his favor. In certain countries, it is so easy for the police to fabricate cases against people. So these are matters that the courts will have to very carefully peruse, examine and make their appropriate orders. So they are not separate. Concepts are the same. Bail concepts are the same, but in some statutes they impose what is called, in the serious statutes, they impose what is called exceptional circumstances, which is not required for a general offence. Under the General Bail Act, you don't need exceptional circumstances. But in those statutes which I referred to, they have this requirement. If you want to get bail, you have to prove that there are exceptional circumstances. So
exceptional circumstances can lead to being granted bail.
Yes.
But sir, you mentioned something about personal liberties and fundamental rights in that sense, where it is a human rights aspect that really plays into the whole bail situation. Could you please explain to us how fundamental rights like personal liberty relates to the bail law?
Yeah, that is, now we have a very interesting constitutional history, Anuradi. That is, during the British, up until 1972, we were governed finally by the Salisbury Constitution. There was no Bill of Rights. Then, with the Universal Declaration of Human Rights, it became important and necessary for all countries who are member states to incorporate fundamental rights into their system. So our first attempt was in 1972. Under the first Republican Constitution, there were fundamental rights which were pronounced in a particular chapter, but they were not enforceable. That was a problem in that Constitution. They did not say how to go, which court to go. Then that was covered by the 1978 Constitution, which we are experiencing now. You see, the entire world has changed because with the Universal Declaration of Human Rights and later on the ICCPR, the concept of rights have evolved. Earlier, you look at, now if you take criminal law, as I told you, criminal law, we have a great influence from the English law. In England, there was what is called canon law. That was church-based law, which was very rigid. In the eyes of God, everything is an offense. So likewise, what happened was, with the development of the concept of human rights, ICCPR, people becoming more aware of their rights, people started, when they started complaining of violations. The question is, today, a court of law dealing with a bail application cannot do so as they did in the 1940s, 50s or 60s. Today, the concept of rights have emerged. But the problem is, rights, now say every one of you have equal rights, I have equal rights. Another third person will have a third equal right. He should have an equal right. But the problem is, it's all criminal activities based on human conduct. If you and I don't commit an offense, we have nothing to worry about. But the moment somebody crosses the line and commits a criminal offense, at that point, he is subjecting himself to the criminal justice system through his own conduct, through his own volition, through his own habits. So when that happens, he will have a right, he will have fundamental rights, all that is there. But the moment you subject yourself to the criminal justice system, apart from the rights that you speak of, which you derive from the Constitution, the normal law has to take its course. Whether it is you, me or somebody else, the law can't be different. The normal, that is something that the society and the public in general should understand. It is not expected to be it is not expected to differ on the individuals. It's the concept. I have a right, as long as I don't trouble any other people with their rights, I am entitled to remain peacefully. That is the freedom of movement. The moment I cross the line and do something criminal, which is an act against the state or in the criminal justice system, I am subjecting myself through my own conduct. Then the law has to take. Then you can't complain, you can't arrest me. You have to be arrested if there's an offense. Then you have to be dealt with as others in the normal system. That is what the judges and the people of this country have to realize.
There is no way for us to exploit a system when we know that we have stepped out of bounds of the law.
Yeah.
So,
and then complain our rights.
Exactly. Fundamental rights cannot be the be all end all. It can't save you if you have committed an offense, of course. But we should definitely get into the aspect of procedure, how it goes about when you apply for bail, how different it is when applying for bail for different offenses, and who can actually, how you can be entitled to bail, of course. But before we get into any of those, let's take a very short commercial break. You're watching Law, Land and Liberty. Stay with us.
My name is Pereira and I am a businessman. My question is on bail procedure. How do the courts grant bail and does the criteria differ across the spectrum?
Welcome back to Law, Land and Liberty. We were in conversation with President's Counsel Kalinga Indatissa, and we were talking about bail laws in Sri Lanka. Now, sir, before we left off for the break, we were talking about how fundamental rights cannot be the protecting wall. If you have committed an offense, you have subjected yourself to the normal ways of the law. And so we get to the part where we have to come to the point where we apply for bail, where we need to be granted bail. So if you could guide us through exactly the procedure that has to be followed by accused when requesting for bail.
Yeah. Now the first commencing step is, I must say one thing, taking from what you just said, fundamental rights cannot cover yourself if you have committed a criminal offense. But still for all, the law enforcement authorities have to act within the procedure. Otherwise, you can't assault people, you can't torture, right? So yes. Therefore, that aspect is another matter that is in public law and in the concept of fundamental rights that courts will have to consider. Now, how do you get bail? The first step, as I said before, in the first segment is you arrest a person. Arrest must be on reasonable suspicion or credible information on reasonable material. You can't just go on arresting people. Then you produce him before a magistrate's court, which is at the lowest ebb of our structure. That is where you deal with the rights of people, real people. So when you are produced, the question is whether he should be given bail or not. If it's a bailable offense, prior to 1997, he has a right to ask for bail. You should please release me. I have a right to be released. and the magistrate could not have made any order other than to release. But with the change, that is something which runs counter to the concept of the Bail Act. Even in a bailable offence, magistrates can remand now, and they do. But they have to be very cautious in doing so. Bailable means basic, simple offences. So, when you are brought before a court, you can ask for bail either by yourself or through a member of the legal profession, a lawyer. Then you have to satisfy if it's a bailable offence, that is the procedure. Even in the case of an unbailable offence, when this person is produced before the court, the lawyer can ask for bail. Even though non-bailable, I told you, does not mean that you can't get bail. That depends on your past conduct, your standing in society, whether you have committed previous offences, whether you are a problem for the entire community, or the nature of the offence, brutal nature, or it's a simple thing. Those are matters that the court has to consider. There are only 4 considerations. Normal rule in the Bail Act is you have to grant, wherever Bail Act applies. I told you there are certain laws to which the Bail Act would not apply. Wherever the Bail Act applies, the rule is granting of bail shall be the rule, refusal is the exception. That is embodied in the Act itself. That is the purpose why the Act was passed, to make it more relaxed. Under Section 14 of the Bail Act, you can refuse bail. The magistrate's court can refuse bail only on 4 grounds. If it appears that the suspect will not appear at the inquiry or trial when noticed, that means he doesn't have a permanent place of residence. He doesn't account for himself or where he lives. Or if it appears that while on bail that he will commit a further offence, that is where his previous conduct would come into operation. There is a habitual offender, he is going to do this. Then thirdly, if it appears that he will obstruct the course of justice or interfere with the witnesses. Now say for example, I am taken into custody. My main witness is an employee who is under me. The moment I am released, there is a degree of influence that I can get her to change the statements or change the story. So if the court feels that, the court can remand me. And then the final thing is whether there is a public outcry. There are some, now I remember there was a case in Jaffna where a girl was brutally raped and murdered. In that case, there was a public outcry. But public outcry doesn't mean that you hire some people to stand outside the courts holding boards and placards. Either give bail or don't give. That is something organized. So the courts will have to necessarily consider whether there is a genuine public outcry. On those 4 grounds, the court can refuse bail. And then, once the dangers are not there, grant bail after some time. So those are the 4 considerations that the law will look at. In other statutes, I told you that the different statutes, poisons, opium and dangerous, that's where you read exceptional circumstances. The person asking for bail has to show, please release me because my circumstances are different to the ordinary circumstances. Now there again, one fundamental thing that I want you to remember that we should discuss is, sometimes police have the habit of producing people without any evidence. That has happened, that is happening, and that will happen. So how do you deal with that situation? That is where the magistrates will have to be cautious. Whether first thing, before going into any other principle, right, the magistrates will have to look at, is there a criminal offence punishable under this particular law that the police are referring to? Now I know of certain cases. Public Property Act. Public Property Act was passed in 1982 by the Parliament when transformers were burned in the south and transformers were burned in the north. So, in order to dilute the situation in respect of public property, the Act was passed. Now the police used that as a mechanism to remand people, because once you are produced as a suspect in a public property case, it's difficult because the Bail Act will not apply. The applicant will have to prove that there are exceptional circumstances. But before going into the public aspect, the first thing that a magistrate's court should look at is there an offence under the public property law? Sometimes they will cite a law. But technically, if you look at that in detail, the situation doesn't fall under the Public Property Act. So those are the grounds on which, 4 grounds I told you, you can refuse bail. Otherwise, the court exercises discretion. Discretion can be used in favor of the individual once an application is made.
So exactly to build on the discretion, now the guidelines with which the court operates in granting bails, how does that actually, how can we understand exactly how the court chooses to grant?
Now I don't want to bore you, but there are the English during ancient times we have followed 2 main cases. There's one reported in 12 New Law Reports, page 65, Rex versus Toussaint, and other one is 65 New Law Reports, page 289, Queen versus Lienage. There are 4 grounds our courts have identified. Nature of the offence, seriousness of the sentence, possibility of conviction. That is, you look at the evidence and see whether it's 50% or 20% or 75%, and probability of absconding. The court will, that is, those are the 4 grounds that a court would identify as the grounds to base their discretion on. Court has a discretion. Court can't just refuse people bail without looking at those factors. So you will have to, even though now these 2 judgments have become basically obsolete in view of the Bail Act, but what was said in those 4 judgments are the main factors which are embodied in section 14 of the Bail Act, which gives the power of to a magistrate to refuse or grant bail. So basically the court will look at, you can't refuse bail just because you don't like the face of the accused, or you can't grant bail because you like the face. So it's a judicial function with a judicial mind that they will have to apply. So those are the grounds that you will have to consider.
So now we know that there are grounds on which the court has chosen to
the
exception and the rule. There are specific requirements that have to be, it is up to the discretion of the court, but there is a basic outline of exactly how you will or will not be granted bail. So now I think we should move on to a more specific scenario. So you earlier mentioned that, with the Bail Act and of course the differing acts that have bail in their statutes, how does that differ, the process? Does it differ greatly or?
Yes, to a large extent when it comes to the time factor. Normally what happens, Anuradhi, is in a normal simple case to which the Bail Act would apply, lawyers would make oral applications. No documents involved, no drafting involved. If there are exceptional circumstances in an extreme case, you will have to do an affidavit or file some papers and draw the attention of court, paragraph by paragraph, that this case contains exceptional circumstances. The problem is, now there are situations, in my opinion, in any country, judges have to be vibrant. There are 2 factors. Especially in the context of criminal law, you have to be mindful of the impact on the society as far as the act of the accused is concerned. What he has done, how does it impact? Secondly, the rights of the accused. Those things, you have to strike a balance. That is why a judge would be there. So in that context, what I would say is, in normal bail applications for which the Bail Act applies, it's an oral application, but otherwise you have to go and file. First, sometimes you have to make certain offences, the Magistrates Court can't grant bail. PTA, poisons, opium and dangerous drugs, over and above a particular quantity, you can't grant bail. So there is no point in making applications in the Magistrates Court. All what you do is, you have to think of your application in the higher court and make certain, identify the gaps or the issues that the prosecution's case has. So otherwise you have to go to the High Court and file papers, petition, affidavit. Then it takes time. It takes a minimum of, in my understanding, minimum of 12 weeks. 12 weeks, minimum of 12 weeks. It can be more. So now the law is, if a person cannot be kept in remand for more than 1 year. Remand means not after conviction, pre-trial. You can't be after 1 year. Maximum period is 1 year, unless there is a request by the Honourable Attorney General to say extend the period. Right? So, what I say is, the difference is, normal cases, oral applications, the time that you consume is less. But in exceptional matters like narcotics, PTA is huge. You detain people for a long period of time, there must be an objective assessment. There is provision, even under the current PTA, there is provision for a committee to vet during certain periods. You can vet it and find out whether this person has to be kept in remand any further. But that is not being done. That is the problem. So it takes, whenever there are exceptional circumstances to which the Bail Act will not apply, it takes a longer time to get bail.
So there's a bit of a gap in the legislature.
There's a gap and there is no system of reviewing.
Exactly, there is no system of reviewing. So there could be unjust remands as well. We have to get to that in the final segment. But before that, sir, you mentioned how it's up to the discretion of the Magistrates Court to actually grant or not grant bail. Sometimes it is not capable to be granted through the Magistrates Court. So I think it's important for us to understand how pivotal of a role does the courts play when it comes to granting bail.
Yeah, because, you know, courts are the guardians of rights, no, and duties. So courts has a huge role to play in the context of granting bail or refusing bail. That is why I told you there are two factors. What the suspect has done and the impact that the act has on the society. Secondly, the rights of the suspect. Thirdly, the court must go into the evidence that is available. You can't, courts are not expected to be rubber stamps of the police. You can't just endorse what the police says. If that happens, it is very unfortunate. If you only go by what the police says. And on the other hand, I cannot do better than to quote a judgment of British courts which was adopted in Sri Lanka, Ceylon, Christie versus Lechinsky, adopted in Queen versus Korea. A police officer in England and Ceylon both have their methods of extracting information from suspects. That is why the law does not trust the law enforcement here, England, everywhere. That is why that sacred function is placed in the hands of court. So the courts must be cautious about their role and they should look at all factors. I am not saying to grant bail in every case. I don't say that bail should be refused in every case. You must strike a balance and see whether by granting bail, what is the loss that will be caused to the prosecution case, or by not granting bail, what is the loss that will be caused to the other side. Those are factors, the balancing factors have to be looked at.
It is a balancing act, and of course the courts ultimately should be there to serve justice to the people. There should be when it comes to the enforcement authorities, of course there is an issue there, a small bit of a gap, I guess.
In every country.
In every country. Yes, regardless of...
If you take the Guildford 4 case in England, it's one of the greatest miscarriages of justice in the British legal system. How they hid evidence, how they suppressed a statement of a witness. And as there's Guildford 4, Guildford pub bombings case, that exposed the entire police system of the British in the UK. So everywhere that problem is there. If there's a periodical review of how many people arrested, what are the grounds, maybe, I don't know, maybe by not people in the police, but people who can have an objective assessment rather than have a partial assessment.
A third party look into the entire system.
Yes.
That should be, actually we should be discussing that in reforms as well. We do have to talk about the anticipatory bail aspects, but unfortunately we run out of time in this segment. So we'll pick that up right after this break. Stay with us on Law, Land and Liberty.
And I am a journalist. My question is on reformation. What are the biggest shortcomings of Sri Lankan bail law and how can it be reformed?
Welcome back to Law, Land and Liberty. We were in conversation with President's Counsel Kalinga Indatissa, and we were talking about the bail laws of Sri Lanka. And of course, before we left onto the break, there is a very significant area of the law that we couldn't discuss in the previous segment. So I believe before we get into the reforms aspect, we should probably address that as well. Sir, could you please explain to us? Now, we know exactly bail, how we are granted bail for things that we have done, and we have been in contact with the authorities, and that is how we ended up needing the request for bail. But there's this concept called anticipatory bail, and I believe a lot of the viewers watching today will not have a clear understanding of exactly how that works, because it feels a little bit like a go home free pass before there is any sort of authority work that has been done. Could you please explain to us how anticipatory bail functions?
Anticipatory bail is a concept which developed in Canada. Then anticipatory bail is a concept that is very popular in India. Anticipatory bail is governed by Section 21 of our Bail Act. For the first time in our country, we have introduced this concept. What does it mean? If a person knows that you are being looked for by the police for a non-bailable offence, not bailable, not narcotics and other areas where to which the Bail Act will not apply, a general non-bailable offence, he can go to court before he is arrested, before he comes into contact, if I were to use your very words, before he comes into contact with the law enforcement authorities. He can go to court, file a petition affidavit and say, there is a complaint against me, I am being looked for, this is what I have to say, explain yourself. You have to be very careful in the documentation that you do, because such documentation could be made use against you subsequently at a trial. So the lawyers have to be very cautious. Please give me bail because of these reasons. I have a permanent place of residence and I have not committed previous offences. I am not a habitual offender. There is no likelihood of me committing further offences if bail is granted. And also there is no public outcry. The idea, because in a highly politicized country, where politicians want their opponents remanded, this is not what I am saying. I will keep on saying this. But in India, several Indian judgments show in a highly corrupt nation, where politicians would want their opponents remanded, anticipatory bail is a mechanism that is given to them to enforce their rights.
We have recently seen such an issue as well.
Yeah, so that is a right that everybody has to exercise. Courts, it doesn't mean that you have to give anticipatory bail. Sometimes you can circumvent the procedure, avoid, wait with abscond, and then come and ask for anticipatory bail. Whenever an application is made on anticipatory bail, the law doesn't require the magistrates to grant bail in every case. You have to look at the factors. If I give this person on bail, would he have the opportunity of hampering with the investigations? So all those things the court will have to consider. But it's an important concept.
It is.
It is.
Definitely, because considering exactly what you mentioned, the politicized nature of the environment right now, it is basically a tool that has been evolved to fight certain underhand tactics as well. And of course, there is discretion, unlike what a lot of people consider that there is no discretion. It sounds like exactly there is no authority that is governing such a thing, and it looks like an omnipotent power, but it isn't, of course.
No,
exactly. And that is where I would like to go into our final segment, sir. Now, we were talking throughout the discussion, we were talking about how there are gaps in the entire system and how it needs a review. So, sir, could you please explain to us that where do you believe there are shortcomings, serious shortcomings when it comes to the bail legislature? And do you believe that there is an overhaul necessary, or if we should be amending?
No, I don't think we need an overhaul. No, the law was carefully drafted in 1997. I will first talk about the Bail Act and then the other laws. In 1997, it was well drafted. The only thing is, I would like that now, as I told you, anticipatory bail is only applicable for unbailable offences. It is not applicable for bailable offences or for unbailable offences where you have to go to the High Court to get bail, like murder. Murder, magistrates can't grant bail. You have to go to the High Court. In India, that possibility is there. So what I suggest is the Bail Act, Section 21 should be amended to, if the overcrowding of the prisons and unnecessary remanding of prisoners by courts were the problem. In order to solve that problem, they can further relax Section 21 by bringing in bailable offences and other unbailable offences where you have to go to the High Court also in the realm of anticipatory bail. As far as the offences where you have to go to High Court to ask for bail, being brought under the anticipatory bail concept, it is done in India, but we might have to have we have to sit and study the impact that it will have, because then everybody will start granting anticipatory bail. That is another problem. Then the society will have a problem about people being available freely. So because of that, that's just one of the things that I want to say. Secondly, on other statutes, now you take the PTA. From the time the PTA was drafted in 1979, there have been constant complaints. PTA is an important piece of legislation. Lot of people, there is a lot of debate wherever, but a lot of people, they don't know what they are talking of, because there is a concept in law called salus civitatis suprema lex. A law dealing with the security of the state is the most paramount thing. So, security of a nation is very paramount. But that doesn't mean that you can abuse the other rights of people. So, the problem, I have actually written a book on this. One of the problems I foresaw at that time was the PTA, which was drafted in 1979, had certain gaps. That is, there must be a system to periodically review the remand of people. You can't just remand people. There are people 4 years, 5 years, 6 years in remand. The entire life is gone. Of course, there are two options. The justice system should have a mechanism to try these people as soon as possible, expeditiously. So once you are convicted, then you will not have the same benefits that you would have otherwise, prior to conviction, when you are a suspect only. So therefore, number one, that's a problem in the system. We will have to sit and identify more speedier mechanism, at least for these laws.
So do you believe that the unexpedited nature of our judicial system is one of its biggest shortcomings, or is it the biggest shortcoming when it comes to...
No, that is a problem. That is a problem, but you have to understand. Now, as lawyers, if you take me as an individual lawyer, I will have only one case in a court. But a judge will have to dispose of about 300 to 400 cases. How do we do that? The problem is we must make our system more simplified. There are certain matters where we need not go to court. Now, mediation board was a very good concept, you can settle. Then maintenance cases, right? Maintenance cases, 75% of the time of a magistrate's court is wasted on maintenance cases. So what we need is simplify the methods. Identify judicial mind. The judges should be able to identify what is to proceed, what is not to proceed. And also, on the question of bail, I believe there should be reforms in every law, where there are additional conditions insisted upon, like exceptional circumstances, no bail until the conclusion of the trial. There must be a periodical review, not necessarily by policemen, not necessarily by prosecutors. Now, the laws are being drafted by the prosecutors and others, no. Very few times, people will consult the others. So, not necessarily by the prosecutors, not necessarily by the defense lawyers, not necessarily by retired judges, by civil people, who can look at a problem objectively and see whether this remand is reasonable or not. You are dealing with the rights of people. Rights of people, he may be a suspect. Then if he is a suspect, charge him, indict him, have the trial, conclude, and then you convict him if there is evidence. If there is no evidence, you have to acquit. Otherwise, what will happen is, the day, and I firmly believe, a law dealing with national security is a very important aspect for a nation. But we have a law, the Prevention of Terrorism Act, it has to be modified in the context of the people's rights and liberties, which has developed over the last 2 decades. Right? So, what I say is, reforms are needed. Anticipatory bail, we have to have a re-look. Then, the procedural aspects, that is not in the Bail Act, procedural aspect in the High Court, it takes about 12 weeks or 18 weeks for a person to get bail. You have to retain lawyers, you have to spend your money. Then a family is at home not having something to eat sometimes, most of the time. So in order to cut down the delays, the courts must have a speedier mechanism. You say when the bail application is supported today, you say on this day it is inquiry. Identify the date of the inquiry, then both parties can present their case and the court can make a decision. So reforms are necessary in that context to the Bail Act, the special laws and also the procedures.
And finally, sir, just before we conclude this discussion, because we have come to the end of our time limit as well, sir, when it comes to injustices against people that have been bailed, so bail injustices basically, are there remedies that are in place?
Yes. You know, as I told you, a judge, now say for example, if you are a judge and I am a judge, I might grant bail to a suspect, to the same suspect, for the same matters, you may not grant bail. So you can't call it an injustice. It may be the way that you are looking at it and I am looking at it.
Difference in discretion.
Yes, exactly. How the discussion is used by you and me. Thereafter, you can appeal to the High Court or go by via revision to the Supreme Court, to the Court of Appeal and then to the Supreme Court. That procedure is there. And that happens all the time. Whenever bail applications are refused, you go to the High Court and you get bail from High Court. Sometimes if you get refused in the High Court, you go to the Court of Appeal. Then the Court of Appeal will grant bail. So the mechanism is there.
So we can't say that it is a complete brick wall. There are possibilities.
No.
Of course, remedies are in place and there is a lot that we can do. There is a lot that has to be done as well when it comes to reforms of legislature, as you mentioned, sir.
Anuragi, remedies are there, but the remedies can be quite expensive. That is why I say that if you identify the problems at the lower level, at the ground level, with a periodical review system, you know, those days there was judicial supervision by magistrates of the peoples in remand. The magistrates, I think in certain areas it's happening even now, the honorable magistrates, they go and visit the prisons and they ask them, how long have you been in remand? What is the problem? Why have you furnished bail? So that now magistrates with their load of work cannot be humanly expected to do that now. But if you have an alternate mechanism where people are languishing in jail, you have a period of time, you have an overall review, and then whether the dangers are removed, dangers of granting bail to that person is removed. That is the mechanism. If that works, you don't have to go far to the Court of Appeal and Supreme Court.
Yeah, ideally, that would be the best case scenario, periodical review. And of course, there is a long way for us to go as a country, as the legislature is concerned. But I feel, as you have mentioned, so we have some solid foundations in place. It's just a little bit of working into the cracks that we have to think about. Well, that's all the time we have for you today, sir. Thank you very much for taking time to speak to us and to enlighten our viewers on exactly what bail is. And I feel a lot of us learned that bail is not just a ticket to go free, but and not just afforded by the rich, but it is a provision available to all, and it is something that the court protects as a right for the citizens of the country. Thank you very much, sir.
Thank you for having invited me. Thank you.
All right. Well, bail is a provision that has been misunderstood by many due to its seemingly controversial nature. From the impact of wealth-based detention to the use of risk assessment tools, there is much to consider as we seek the balance for the need for public safety with the presumption of innocence and the right to liberty. We leave you tonight with the words of the leader of the Workers' Party of Singapore, Pritam Singh. Bail is not meant to be a punitive measure. It is not meant to be a way to incarcerate someone even before they're found guilty. It's really meant to ensure that a person comes back to face charges. That is all from us here at Law, Land and Liberty. If you missed today's program, you can always rewatch by catching us on our YouTube channel, youtube.com/AdaDerana English. I'm Anuradhi Vikramasinghe. Have a great night.